under exceptions, that some artistic creativity is excluded. So with regard to the desirability issue that Honorable Swart is raising, if we can also deal with the desirability of these exclusions, as we say, our society is very multicultural, multi-ethnic, and we shouldn't do things piecemeal. Any other honorable, Honorable Breitenbach, Honorable Mutapo, Honorable Skosana.
Thank you, Mr. Chair. I'm very large in this thing that I'm with the directors. Thank you, Mr. Chair. I'm largely covered by the Honourable Swart and his comprehensive input. I'm concerned about the bona fide requirement, as you mentioned, that's an issue. I'd like to be sure that we're going to take public participation in the committee. Because I would look forward to that, and I'd like to know from Mr. Bassett some summary of the public input that you got. If we could perhaps have started that, I'd be very interested to see what they were. I mean, I don't want to trawl through all 75,000, but if you've got some sort of summary of them, that would be very helpful. And then we'd have to, as the Honourable Swart said, we'd have to consider very seriously the overlaps with other legislation and the common law. We're passing a lot of legislation, and it makes it very difficult for people who have to prosecute them when there are 5 or 6 or 7 different pieces of legislation that deal with the same thing, to sort out who does what, where, and when. So we just need to bear that in mind. Thank you.
Honourable Skosana. Honourable Mutaba, I'm sorry.
Okay, thank you, Honourable Chairperson, colleagues, Deputy Minister, Advocate Basson, and team. Media. Thank you so much for the presentation and for the summary of this very important bill. What I would like to know, Chairperson, is since 2001, as Honourable Swart has alluded to, and the Chairperson, there has been key strategic guidelines, strategies, and plans. You know them. The Urban Declaration and Program of Action. 2003 is National Forum Against Racism. 2009 is National Policy Guidelines for Victim Empowerment. And then, the National Development Plan is fine. Then we have the National Strategy for Developing an Inclusive and Cohesive South African Society. And then again, there was a research by South African Human Rights Commission, which I requested the Secretary to submit to members, which I think will be very much important in when we engage with this bill. What I would like to know is whether, Advocate Basson, you did take into consideration all these key strategic guidelines into consideration when we were busy with this bill, because it appears they are very, very, very important to in the finalization of the bill. And again, on the issue of PEPUDA, Honourable Swart did make mention of sections 25 to 28, which up to now are not yet implemented. And again, there is a section 10 which has been declared unconstitutional of the same PEPUDA. And I'm happy today, at least some of us were aware that PEPUDA deals mostly with civil inequality cause, and this will deal differently with criminal cases. So what I would like to know is because we have been informed that Pebuda was supposed to be amended, but up to 2017 we haven't received anything. Then that's why I say somehow aligned to what Honorable Swart have just said. So the impact it will have on this bill, if those amendments will be made later, and the Section 10, which has been declared unconstitutional. And again, the issue of draft national action plan, which is to be submitted to Cabinet by end December this year, the impact also thereof. And the issue of traditional issue relating to our tradition and custom. You're aware that Section 30 and 31 of the Constitution does recognize traditional, cultural, linguistic communities. And therefore, I would like to know, because we have here, this bill is creating hate speech, isn't it? Therefore, I would like to know, in terms of there's somewhere in this documentation I've seen where you relate to religious belief and so forth. So I'd like to know, there are other things. Deputy Minister John Jeffries made mention of an example of throwing a young boy throwing or girls throwing a stone at a mosque because the intention not known. So I would like to know, in terms of the religion or belief, there are people who hate some of the traditional practices, isn't it? So will the same be said of that, of a person who will be behaving in a similar manner as the example which the Honorable Deputy Minister has referred to? Let me take an example of initiation school. Initiation school, then a church not being far from that. So the initiation school being practiced, singing. So the church people becoming infuriated, go and ban that initiation school. Will that also fall within that category of that? And some terminologies, like we said, we used to say in rural areas, even in Xhosa, if you are not circumcised, you are called Inkwenkwe, isn't it? Lishuburu in our culture. So someone may take you up in terms of that. So also, please clarify me on that. And again, on issue of exemptions, I didn't get it clearly, Deputy Minister, exemptions, if it can be explained thoroughly to me. And also there is on the issue of prevalence, I think the Honourable Chair and Honourable Swart touched it very clearly, and the Vicky Momber case and other cases which the parliamentary staff did mention here, a lot of them. So I think this bill, honourable members, is long overdue. It's long overdue, has been overtaken by events. That's why when Ms. Momberg was found guilty of this criminal injury and jailed 2 years, everybody was puzzled. Hey, is it so serious? Because people undermine the criminal injury part of it. That's why I say this DM is long overdue. Thank you, Chairperson.
You know, there's a publication called The Rebus, which is written by learned lawyers.
By?
Learned lawyers, okay, who are supposed to represent us in the courts. It raises the question that Honorable Mutabo raises. Is cultural male circumcision compatible with international children's rights? When lawyers who are supposed to represent us in courts still ask this type of questions, where are we going? doesn't it mean that we are even running ahead of the lawyers that we have to rely on to defend us?
But can one just say on that one? I mean, I agree with you. It's pretty. I haven't read the article. The LSSA rep didn't give me a copy. But I mean, you know, they complain about cultural circumcision. But what about religious, which is of young newborn babies, which the Muslims and the Jews do? You know, so
okay, we'll give you more time, Honorable Deputy Minister, because I think this raises an important national debate, and I think South Africans will be happy that you tabled such a bill, so that we really can deal with matters that are at the heart of our facing our society. Honorable Scosan, follow up.
Or are you leaving now, because
No, the 20 past.
Oh, maybe
maybe
with
say something.
can we allow Honorable Buthelezi to speak first?
Thank you, Chair. I didn't have much to say because what I wanted to say was covered by my previous colleagues. So I wouldn't have anything for now. Thanks.
Okay, Honorable Scosan.
Yeah, no, thanks, Honorable Chair, and greetings to honorable members, the Honorable Deputy Minister, and the House at large. Yes, indeed, we were dealing with a very complex matter here, which is not easy. Well, I want to know which matter that you raised earlier, Honorable Chair, on the issue of the regional courts, the accessibility of regional courts to our various communities, because I mean, ordinarily courts that are closer to our communities are the magisterial district courts, the traditional courts also. So I'm just wondering as to how our people are going to be able to access the regional courts in terms of this matter. But secondly, the issue of step-by-step of reporting the cases on hate speech. What would be the first step that a person must then take to report such a case, if it have to be taken to a regional court for prosecution? Now, the third question I see on the issue of the exemption that says on clause 4.2d, excludes from the ambit of hate speech any bona fide interpretation and proselytizing or espousing of any religious tenet, belief, teaching, doctrine, or writings. And I've heard one of my colleague, Honorable Swart, indicating that, well, from their side, they are happy with the thorough consultations, I think, of the department with various religious leaders on this. Because when I look at it, I think religious, or a religion is in its nature, one religion opposes the other one. So when a Christian preaches, in most of the cases, he or she will offend a person maybe who believes in a traditional religion. Because he would say, in Christianity, you don't have to do this. If you are doing this, you are doing that. And that what he or she will be referring to is what other people's beliefs in. See, so I'm just looking at these things of exemption to say, because the understanding is that you are preaching, this is Christianity, this is Muslim, this is Hindu, this is African traditional religion, so there's that exemption. But now what about the rights of those whom, while you are preaching your own religion, you then, I think, in a way, taking down the dignity of the other religion? I'm just checking on that as to how are we going to then pass there. And then also on the issue of artistic creativity, I think on the same page, which is page 6, which speaks about clause 4, it says artistic creativity or performance or espousal of religious doctrine will not qualify for exemption from hate speech if it advocates hatred that constitute incitement to cause harm based on any protected grounds. Well, I've underlined the if it advocates, but on the artistic creativity, because, for instance, when you look at the issue of comedians, most comedians, well, normally when they put their jokes, it would in a way offend somebody. Their jokes will be on race, it will be on ethnicity, it will be on various religions, it will be on sexual orientation. So if here we say artistic creativity or performance will not qualify for exemption from hate speech, I don't know as to what extent does it affect those who are practicing or who are in that field of artistic creativity. Because, I mean, in the main, especially comedians, I mean, generally what they are saying in the name of comedy, but it will, other people might not feel comfortable. Well, others would accept that, no, but this is just a comedy. It's not intended to degrade a certain race, degrade a certain ethnic group, or degrade people of a certain sexual orientation, etc., or cultural practice. So I'm just looking at it as to say, how are we going to manage that moving forward? The next point, Honorable Chair, the issue of elevation in terms of the hate crime. I've heard the Deputy Minister indicating that if a person has committed a certain crime, maybe there's an assault, and therefore maybe there's a suspicion that this assault is not just only assault, but this assault, it has to do with race, or it has to do with ethnicity, it has to do with sexual orientation, it has to do with other things other than in it being an assault only. So that kind of a crime must be then elevated. So at what stage do we elevate? Because a person would go to a police station, report and say, there's an assault case, and then it obviously go to the magisterial court. Then at what point do we then say, no, this have to be elevated to a regional court because it's not only an assault, but there's an hate crime part of it. When do we do that? Do we do that when it's at the magisterial court, district court, or whenever there's a suspicion? Maybe at the SAPS, after the case has been reported, when there's a suspicion, it will then be elevated. Because I see it's going to be, in my view, it's a very complex thing. Because when you look at the list in terms of the hate crime, I mean, in terms of the hate speech and stuff, list of the things that we have mentioned, it will only be on the basis of suspicion. It means every time when people of two races, they've assaulted each other, even if there's nothing to do with the race, but there will always be a suspicion that, no, this is it's race-related. Or even people of two different ethnic groups. Just because they belong to two different ethnic groups, it means we have to check as to whether is it not on the basis of ethnicity. If one is disabled, is it not on the basis of the disability? If one is of a different sexual orientation, is it not on the basis of that? It looks more complex in dealing with that. So at what stage do you then say, no, this one will have to elevate it? The last point, which I think my colleagues also spoke about it, the issue of overlapping with other legislations. How do we manage that? Thanks, Honorable Chair.
I think lawyers will have enough business to deal with these overlappings, but unfortunately, I doubt if our lawyers are well equipped to deal with these complexities, because our universities don't teach about our cultures, don't teach about these religions. Now, if Honorable Skosana, you are right to say this is more complex, where are we going to get lawyers who are educated enough to deal with these issues? But also there's this issue of the many documents that went before, whether or not these documents have been taken into account. And also the South African Human Rights Commission reports to the United Nations. We haven't seen the reports that they send to the United Nations on these matters. What are they saying on these matters? And then I think all these reports could have helped throw some light on the desirability or otherwise of the hate bill. I think that should be the central issue that we're dealing with. Is this matter desirable at this stage? This matter is not being dealt with under the existing law. On Deputy Minister.
Yeah, well, if I can start, please allow the officials opportunity to add. Let me start again with the desirability issue. I mean, this bill has come from Cabinet, and it so it's the view of Cabinet that it's desirable. I noticed that Honourable Motapo says it's long overdue. Others, you are saying you don't seem to think it's so desirable. But yes, I can assure you it takes into account all other documents. So, for example, you would see when the National Action Plan comes out that one of the aspects is the criminalization of racism-related intolerances, xenophobia, that kind of thing. And as far as the other, so it's part of that. It's not being seen as the panacea to discrimination. It's just simply criminalizing discrimination. And then the other laws, I mean, you'll see, I mean, the issue of the cybercrime, there's no conflict. Ms. Pillay can speak about the Papuda amendments, but, well, firstly, just on that, Honourable Motapo, you said that Section 10 has been ruled as unconstitutional. I'm not aware of that. That's the section in Papuda that refers to hate speech. And it basically, but the problem is although Papuda refers to hate speech, there's no definition in our law of hate speech. Yes, we've got criminal injuria, but Honourable Swart, does criminal injuria apply to a group? That's one issue. Should we not be saying in this context where there is a lot of intolerance in the country that we need this Parliament to define what the rules are, not rely on just on the courts to build the common law, depending on the various people. You will remember, Chair, I think it was a few weeks ago or last week, that I think, correct me if I'm wrong, but a magistrate said it was worse for a white person to use the K word against another white person. I mean, rather bizarre that it was worse for a white person to be called a K than for a black person. Now, rather bizarre logic that. We don't want to leave it up to the courts to define what is a crime or what isn't.
If that white man is a believer, and in that sense he means that the other white person is not a believer.
Islam did not feature.
There are white people who are Islam.
It did not feature in this. But on the steps taken, it's a crime. You report it to the police station. You report it to the police. And the police would have to be trained in terms of looking at motive. It would be for the state to prove motive. Okay, so, and motives sometimes would be difficult, but the state would have to prove it. I mean, if you look at the Ashton Willemse incident, was it racist, wasn't it? Whereas what he said at the time very much was that his perceptions were that he was being racially discriminated against. But it would be basically so as far as access to courts, it would be access to the police station. You go to the police station to report the matter. It then gets investigated, and the prosecutors decide what happens to the case.
A cabinet briefing with regards to the Justice Department as well as the Correctional Services Department discussing issues
of expression clause. It starts with everyone has the right to freedom of expression. which includes freedom of the press and other media, freedom to receive or impart information or ideas, freedom of artistic creativity, and academic freedom and freedom of scientific research. But this right does not extend to propaganda for war, incitement of imminent violence, or an advocacy of hatred that's based on race, ethnicity, gender, or religion, and that constitutes incitement to cause harm. You will see what we've done is we've added more things to that list. The argument has been used with regard to Papuda, that simply being racially abusive is not, if for Papuda to penalize racially abusive words, expressions, is unconstitutional, racially or other. So in the Koilane case, I think Mr. Koilane argued that Papuda, he had just said not so nice things about gay people. The court found against him. He argued it was unconstitutional for Papuda to say he should be penalized for that. And the court found against him. He's appealing, so that issue has to be settled. I see Honourable Breitenbach has left, but Honourable Horn's colleague, Ms. Diane Kohler-Barnard, she is before the Equality Court. She is taking the issue, raising a constitutional issue that all three factors listed here must be raised. So she's raising a constitutional challenge as well to Papuda. Generally, though, you would find in the rulings of the Constitutional Court, the SARS case where the K word was used against a person, the CJ wrote the judgment, and it was quite explicit that this word was not was very derogatory, and a few other cases as well. But that's where the exemptions come in. So, Mr. Swart, even with the religious exemption, I would say in terms of the Constitution, you cannot advocate in preaching. You can't advocate hatred based on, let's say, race, and that constitutes incitement to cause harm. The Constitution's explicit on that. And the same would apply to the others. But basically, you can say not so nice things about other people or other groups in church, in an artistic display. I mean, we had one Equality Court matter, Chair, from Cape Town, where there was a display in the gallery here. I suppose I should watch my words, but a display on with the symbol F, what's it, little star, F star CK, white people. Okay, and somebody took that to the Equality Court, which actually ruled that it wasn't hate speech because it was an artistic display and the context. Context is important. But we've got, I mean, there's a lot of borderline cases that would need to be looked at. That's hence also the reason for the elevation. But comedians can say terrible things about people of a different religion, but as long as they're not inciting that it's not advocating hatred that constitutes incitement to cause harm. And again, with religious preachings, the same issue. You can say, look, this other religion or this other sect within the religion is bad, they're not good people, they may be going to hell, but you can't advocate attacks on them. That's really the borderline as I would see it.
Honorable Horn, I'm sorry, I recognize they didn't allow you to speak. It's
fine. That's a best sale.
Okay. So yeah, just basically that. Look, I think the committee should be looking at whether the elevation issue, should there be restorative, Mr. Swart. I think it's a valid point. Should specifically on hate speech, should there be an effort to look at restorative justice? As I said, the original thing with both hate speech and hate crimes was, are we not then undermining what it is? And shouldn't the district courts deal with it? Part of the concern was the sort of complexity of the issue from both the prosecution and the presiding officer's part, that you'd want more experienced people to be involved. But let me leave it like that. But if I can then hand over to Ms. Pillay and Mr. Bassett or anyone else.
Okay, thank you.
Deputy Minister.
Thank you, Chair and honourable members, for the questions and the comments that were made in relation to the bill. I just also want to speak to the issue of the desirability of the bill and to deal with the issues of concerns over overlapping legislation. It's correct that we do have the PAPURA, and there are sections that have not been put into operation insofar as the promotion of equality is concerned. It has taken many years, and I just want to say that what we are doing in that regard is those sections require an amendment to make it implementable, which is something that we are working on, and we intend to publish a bill for comment in that regard before the end of this year. The other strategy that we are working on and the document that we intend to put out is the National Action Plan, as was mentioned, which also deals with what do we do to improve relations between different groups in our society. But all of that does not address the criminalization of these serious offenses. Over and above having those strategies, it was felt that in view of the nature of the complaints and blatant racist comments that are made, etc., there isn't a specific law that deals with the criminalization of these offenses. It's the issue of elevation, which our Deputy Minister has spoken to. But over and above that, it also brings certainty and clarity, because if you open a case of criminal injuria, for instance, it is considered it is a common law offense, and it's not considered to be as serious, except for the recent example that we've seen in the Momberg case. But you will have different public prosecutors who may take different decisions insofar as how they implement the crime of criminal injuria, and some may actually regard it as not so serious. But in creating the offences in this bill, we bring absolute certainty and clarity that if you utter those derogatory terms or you commit any of the offences that we intend to create in the bill, that there is a crime to deal with it. And we do away with that. It's no longer open to interpretation. There's absolute certainty. So I just want to make that clear. But I think also insofar as saying how seriously we regard the offences, the decision that was taken in the way the bill is worded to say that only the High Court may deal with the matters and not the district courts as such is because regional courts and the High Courts is firstly because of the seriousness of the offences and in relation to the kind of sentences that can be imposed, but also to say that the DPP must take a decision on whether we prosecute or not. And quite correctly, I think Honourable Member Skosana mentioned the kind of challenges that you will see. For example, if you have a disabled person involved in an assault case, can you automatically say that it's a hate crime? And because you're adding this element of a hate crime, you want it to be proper interpretation, and you want it to be consistent decisions taken on how we prosecute them. So I think insofar as what this bill is trying to do, that's where the certainty element comes in. Also with regard to, there were quite a few honourable members that requested the comments that were made during the consultation phase. We do have a document on that, and I think we can make that available. Insofar as the comment that was made about comedians, we do create an exemption insofar as artistic creativity, but only insofar that it does not incite hatred. And I think it does not advocate hatred that constitutes incitement to cause harm based on one or more of the grounds referred to in that subsection that contains all the grounds of discrimination. I think that's what I want to say for now. I don't know whether Mr. Bassett wants to add anything further.
Thank you, Chair. Just one thing I'd like to draw attention to, Section 7, A2, Clause 7, Clause 7A2 of the bill. Yes, how do you elevate and how do you report and how do you go about prosecuting these cases? It depends on the evidence that is in the docket. But Clause 7 requires the NDPP to issue directives regarding all matters which are reasonably necessary or expedient to be provided for and which must be complied with all members by the prosecuting authority, including on the following: the leading of relevant evidence indicating the presence of prejudice or intolerance towards the victim. So, as I indicated in the briefing, there's an emphasis on training, and part of that training is going to be how do you prove motivation relating to this prejudice, and the NDPP must issue directives on that to make it easier to give guidance to prosecutors on how to deal with those issues. There was also the issue of bona fide double dipping. We will have a look at that and revert. I think, I just wanted to...
Maybe just to add, look, the bona fide thing, as I understand it, and it was Mr. Swart raising it, it's raised for artistic comedians, that kind of thing, and religious. And it's basically that you can't just claim to be a religious preacher. You've got to show that you are, as it were. You can't say something nasty and then claim you're an artist. It's got to be bona fide. But I think the thing can be looked at, but I think that's where it came from. The other issue that wasn't responded to was Honourable Matapo. Yes, I would say that if there are, culture and ethnic or social origin are included in both the hate crimes and the hate speech section. So if there are attacks on people because of their cultural practices, that could be, if it can be proved, a hate crime or hate speech. Obviously, if it's coming from a religious body, then it becomes a bit more difficult because it's subject to that religious exemption, and it would have to be advocating hatred that's incitement to cause harm. So if a church is saying that, people
you heathen there, making a lot of noise.
Well, if it's part of, well, look, the others can. Maybe I shouldn't have jumped into it, but if it's part of the preaching, then simply saying heathens, going to hell, backward people, whatever other nasty things you can think of, that would be allowed because it's of the religious exemption. However, if it's not part of the bona fide preaching, it's somebody is expressing their own view, then it could be hate speech.
If you say that can be allowed,
and 80% of the indigenous people would be offended by that remark, and you say you exempt the person who says it, and when 80% feel offended, don't you think that can even lead to civil war in a country?
Well, look, it's not. Remember, it's specifically from a religion. It's this. For everybody else, it would be hate speech. But if it's part of the bona fide proselytizing or espousing of a religious tenet, belief, teaching, doctrine, so if it's part of the sermon, then I would say it becomes more difficult because of that exemption. But if it's not part of the sermon, then it would be hate speech.
If they say the cultural, they say, "Hey, you there? Hey, just so then what will then happen? Because those things are there, are prevalent." Yes.
If it's not part of the
exemptions,
if it's not part of the espousing of the religious tenet, so if it's just said, then I would think it would be
Agree, Libona. They believe in that culture, isn't it? They believe they are traditionalists. Yes.
But I'm talking
about praying their ancestors.
Yes.
In terms of Christianity, is a taboo, isn't it?
If they have the sermon which says you should not pray to the ancestors, then you've got a problem with the exemption. okay? And I hear what you're saying, Chair, but if it's not part of the sermon, if it's just an expression, then it would be, it could be fall into the hate speech category.
You know, in the center of Johannesburg, already bishops, Christian bishops, are intolerant of the Muslim. When the Muslims call for prayer, there's this minaret. When those bells ring to call for prayer, some Christian bishops feel offended. And as a result, they say some nasty things. Now the question is, it will be Christians against Muslims, each one of them relying on their religious text. It will be 80% of the Africans relying on their cultural practices. The question is, where are we going to get the lawyers educated enough to draw these fine distinctions in this complex situation?
Yeah. But Chair, just a quick response to that. It would be, that's why it's the Director of Public Prosecutions who must decide on prosecuting, not your ordinary senior public prosecutors, and also why Mr. Bassett referred you to that section of the NDPP having to come up with guidelines.
Okay, Honourable
No, Chair, I think the examples are illustrating the difficulties with hate speech, the broadness. Because we're talking about, if you have individuals, then it is far easier. If you've got groups, as you correctly say, there are Christians that might say something that might offend other faiths or traditional, but it works the other way as well. It works the other way as well. That you might have Muslims saying something against the Jewish faith, or Muslims saying something against... So this is the challenge, where you've got groups involved. Where you've got individuals, it's far easier to determine this. And Deputy Minister, I'm concerned when you speak about limiting the religious exemption to preaching, because here it speaks about proselytizing. Proselytizing is a traditional religious person that speaks to a Christian and says, you must come back to a traditional religion. Or a Christian saying to a Muslim, convert. Now so it's not limited. It can't be limited. But if you're saying it's limited, then it's a massive concern. But it can't be, because you said preaching only. Many faiths go out and walk, the Jehovah's Witnesses goes door to door to door. And that could be very offensive to other people. So this is what it illustrates the challenge. And you've correctly tried to address the challenges, but whether you've done it sufficiently will be for this committee to decide whether we open up a hornet's nest with hate speech or not, or whether we deal with hate crimes. I think that is the biggest ambit. But I just wanted to ask you on the bona fide. You see, you haven't addressed the issue of raising the bar above what the Constitution requires. Double dipping is the first issue. But the bona fide artistic creativity is not in the Constitution. There's no such thing as that. But can I ask the test? Is the test for harm subjective or objective? To me, that is my concern, is that it appears to be subjective from the view of the group or the individual. And that is the challenge. That's the last. And the last issue is what the chairperson said about the overcrowding of our high courts and our regional courts. They're not dealing with it now. We've just done the budget. You know the overcrowding. Now to elevate, I can't see it ever justifiable to elevate hate speech to regional court and to the high courts. They are so overcrowded at the moment. So these are issues which we will unpack, but I want to emphasize our gratefulness that you are seriously and you have been engaging with the various communities and their concerns. And I think, Chairperson, this requires a broad engagement of all the different sectors, which I think will be helpful as we go forward. Thank you, Chair.
There's a follow-up by Honourable Lutapo, and then let's welcome the Minister and allow him
Minister,
to
I'm sorry, I didn't acknowledge you as well.
We'll talk about what
proselytizing,
Proselytizing.
going out to recruit
Evangelizing.
people, evangelizing, recruiting people
to your own religion.
Okay. Minister and Deputy Minister and Advocate Basson and your team. That issue of Bassett.
That is a former Chief Master.
Okay. The issue of, I asked a question relating to beliefs. they believe. Is it also inclusive of traditionalists? Yes. Mm. Because somewhere in the early
Speak into the
2000,
mic.
there was this issue in Limpopo where there is an association now in terms of Traditional Healers Practice Act. They are now mobilized under Dr. Gianni of Skukuneland. I was telling our secretary to involve them in the whole thing. They approached us, a firm of attorneys in Polokwane, Mangwe Magabane, because the South African Council of Churches, where most of these churches belong, Christian churches belong, are members, we're holding a sermon somewhere and saying, please stop praying, honoring ancestors, because in terms of their language they say, "Kima demoni," they are demons. So they approached us to say, no man, we are not happy. Very angry, very, very angry. The religious people are saying, our ancestors, whom we honor, as traditionalists, we believe in ancestors. They are saying our ancestors are demons. Please deal with these people. So we organized a meeting between the South African Council of Churches and traditional health practitioners, healers practitioners, to try to mediate. And they were very, very, very angry. So if this bill is intending to address such things, I'll be very, very much happy. And unfortunately, before the minister came, there was no response in that regard in relation to traditionalists. That's why I wanted that term which was used. Does it also include what I'm referring to? Because I understand you consulted on with religious leaders, but they were somehow excluded and they are mobilized. I remember I even told our secretary to involve their chairpersonship, Dr. Gianni, in that regard. Thank you.
And they are a statutory body.
It's also assisting the Minister of Health in advising him on other. They are sitting on his advisory board.
Okay. The Minister wanted to say a few words, and then can I also respond at the end?
Okay. Honourable Minister.
No, thanks, Chair, and apologies for coming late into the debate. In any case, the entire legislative program of the department has been delegated to the Deputy Minister, as you may well be aware, and therefore I've played a minimal role in most of the legislative processes. I may just indicate that when the bill initially confined itself, and it's in a sense in response to the proposition that the hate speech component be dropped. I'm not sure whether that was a firm proposal, but if that be so, I would want to respond in this way, that when the bill initially was put together, at some point, the issue of hate speech in particular was dropped. We had a very long engagement between myself and the Deputy Minister to say that it would be most unfortunate if in the phase of resurgence of hate speech, to the extent that even the courts have come to the party, as we all are aware, and actually taken the lead by not only giving civil relief, by going further and granting criminal recourse to those who feel that they have been the victim of racial assault as I would put it, and other forms of prejudice, we will once again find ourselves as a parliament opening ourselves to criticism that here we are again failing society by not taking the bold step of ensuring that as the parliament of the people, we lead in giving full effect to the objects of the Constitution. You'd recall the criticism that we had in the Nkandla matter. I think, and in other matters, I think that this parliament should be bold in executing its constitutional mandate and lead society. That's why we're here, as a general rule. Now, coming to the specific issue, let me also indicate that it would be unfortunate that when the matter is already settled at common law, which dates back 2,000 years ago, long before issues of racism in the manner that they present themselves in our context, for example, that is underpinned by a legacy of colonialism, etc., had already given relief, recourse, with regard to abuse of speech that is offensive enough as to cause harm. We come in 2018 and say, this is a matter that we're going to defer. Defer till when? When Rome is burning. So I really think that we'll be failing society, in my opinion, if we fail to seize the moment and actually assist the courts in further strengthening our tools, or their tools, to be able to deal effectively with the scourge of not only racism, but other forms of social prejudice. So that would be my starting point, really. But getting into the specifics, I mean, again, if the common law has been able to delineate between that which is offensive enough to attract some form of penalty, civil or criminal, surely we should equally be in a position, with all the jurisprudence that has evolved over the years, that has offered some, or should offer some, guidance as to where the line could be, armed further with the clause in the Constitution, we should be able to. I mean, in responding, for example, to the question about religious assault, I mean, I do not see difficulty here. And maybe it's because I'm too blind to see. Because when I was still at university studying law, I used to have a pastime reading different things. And I took time at some point to read about the history of Christianity in the Roman Empire when persecutions occurred. And my limited understanding of the literature that I was able to go through pointed to the fact that the Christian religion was intolerant of other religions, to a point where the Roman Empire felt that it was becoming a threat to the integrity of the empire. And that's what gave birth to all this persecutions and the martyrdom, etc. And my understanding is that the Christians were conscious that they, in fact, were intruding into the faiths of others, and by seeking to impose their own faith over those of others, by calling them paganism and everything else, and calling on everybody else to subscribe to no other religion except the Christian religion. So it became a political issue. And I think that those are some of the historical experiences that society has gone through to arrive at a conclusion that says, for the sake of harmony in the world, actually, religious tolerance must be the order of the day, so that no religion should seek to undermine, to castigate any other, right? So I don't think that anybody has a right under our constitution, for that matter. And in response to Memutapo's point, to go out there and actively castigate and indulge in provocative, utterances and conduct that would disturb the peace in society. So personally, I don't see a difference, and I think the Christian religion itself, and that may well be true of all other religions, have come to terms with the reality that the only way that human society can live at peace with itself is to acknowledge the right for coexistence of different cultures, different religions, different linguistic groups, etc. And that is what I believe underpins the kind of constitutional order that we have adopted, and whatever these laws are about seek to reinforce that. And for me, that is the point of departure. But I may be losing.
Thank you, Honorable Minister, for throwing some lights on this. I'm just wondering whether, having received this briefing, as a committee, we shouldn't sit and, on our own, deliberate on the issues that arise, and also seek our own legal advisors from Parliament before we take this matter forward. And it's a pity that the Honorable Minister was not here when we started, when contradictions were pointed out and other laws which were not yet put into operation, and other sections which were declared unconstitutional. And now the Honorable Deputy Minister said he was not aware of that, that it would seem that, and most of us here hear some of these things for the first time, and then we might need time to internalize and go through this. For one thing, sure, as some of us believe in an ancestors, I even give liquor to a bull as part of that ancestral practice, and some people say, no, this is pagan, they still continue to do so. So what came out was that our society is very complex, so we should take society along, and otherwise we may end up jailing more than 60% of the population, and correctional centers are already full, but there's also a view that this initiative is very important because there's an increasing intolerance in society, and that really means that we have to do justice to what is before us. So can I hear from the members, do we need time to sit and go through this thoroughly debate? But what Honorable Mutapo also made, she listed a number of documents which should have been informed this discourse, whether we should also not ask the department to favor us with all those documents and reports, so that when we meet to talk, we have gone through those documents. Honorable Swart.
No, Chair, thank you. Chair, just at the beginning, it's a pity the Minister wasn't here when we engaged earlier. And I appreciate from our side as the ACDP, we stand for religious freedom. And I think that's the tenet of our constitution. But I think, as Minister, you need to be careful when you say that the religion of Christianity is intolerant in a historical perspective. So one could say that about the Muslim faith. One could say that about other faiths. So I think, although you placed it in a historical perspective, I think we need to be sensitive to how we express ourselves. I find that maybe not justifiable.
Let me immediately apologize, Chair. I'm a Christian myself, and it was
you put it in a historical context.
It was in the context of a specific reading that I did with a specific religion at a particular context. It was not aimed in any way to suggest that the Christian religion is intolerant, even in that context. It was how the Romans, as I understood it, felt it and reacted to it.
I think, if anything, the Romans were intolerant. But anyway.
Well, I accept. I'm just saying, let's not elevate it beyond what it was purely
in
anecdotal.
Response to Ms. Matapa's concern. But Chair, can we deal with your issue? I'll put that position. I agree with you, Chair. We'll close that and we will engage with that outside of this. But Chair, I am 100% in support of your suggestion. I think we as a committee should sit. We've heard what the Minister and the Deputy Minister have said. From our side as the ACDP, we are appreciative, Deputy Minister and Department, of the extent that you've tried to engage. But I think Ms. Matapa might be concerned that we haven't engaged more broadly. And I think, Chair, so I am fully supportive of us discussing the issue. Again, I want to emphasize that we are broadly in support of the hate crimes issue, but we have some issues with the hate speech issue. But let's engage as a committee, and we'll take it further. I would second your motion, Chair. Thank you.
Can I ask something, Chair? Can I ask as well? Let's hear the honourable member so that when you answer.
Well, it was just, Chair, I mean, is this before putting it out for comment?
Pardon?
Is this before putting it out for comment?
No, because
If honorable members still have lots of questions and they are not at one, and we go to the public on something that we ourselves are not at one, we may even create more confusion out there. So I think it's important that as the committee we need to understand, have a common understanding of where we are. What is it that we're taking to the people?
Because, Chair, my concern is, I mean, the usual practice with bills once they're introduced is that they are put out for public comment. Obviously, there may be different views in the committee on a bill. It has been said by members that there needs to be a lot of space for public comment on this bill. So my concern is, if you're going to first discuss issues with the bill and then put it out for comment, the likelihood of this bill being passed before Parliament rises at the end of the term is not so good. What I can assure you is that, I mean, because you raised as part of your motivation the issue of the other legislation and other documents, that this is consistent. Okay, this is not over-legislating, it's consistent. The issue that you said of that I was unaware of Section 10, as Member Tapo said, being declared unconstitutional, I'm not aware, and is anyone aware? Can I please be referred to the case? Because the implication was that the Con Court has ruled that section is unconstitutional, and I'm not. I would like to know which case that was in.
I thought what
I
was
was saying was that there's the issue of desirability.
that as the committee will sit and address the desirability, and that if the department favors us with the documents that Honorable Mutabo refers to, that will help us to overcome that.
But you want to, for the first time ever, you want to consider the desirability of a bill before you put it out for public comment.
No, Chair, I would strongly suggest that sitting here as the committee, fellow member of parliament for that matter, we are not possessed, I would want to submit, of all the wisdom that we will require to guide us even on the question of desirability. I would be more comfortable to a situation where we first allowed ourselves to be influenced by the diverse views out there, which may be mirrored or not even mirrored in the diversity of opinions already expressed around the table here, so as to enrich us to be in a much better position and to even gauge the mood of society generally as another factor that we may take into consideration. Just to illustrate the point, Chair, at some point when I was with social development, we wanted to ban corporal punishment at home in the same manner that we banned it at schools. But it became clear that society was not yet ready for it. So at some point we had to hold back and wait for an opportune time to revisit the matter. So there will always be controversial issues in society which we ourselves sitting on our own may not be possessed of all the wisdom to make a pass judgment as to the state of readiness of society, let alone the correctness or otherwise of whatever position.
Thank you, Honorable Minister.
I thought for today we really were just getting a briefing. And we have received the briefing, and then we have raised issues. And I think all we are saying is that we'll have to meet and decide on the way forward. And then we're Honorable Hon.
No, you're supposed to be.
I agree with you. Thanks.
Yeah, so I think we have received the briefing, and then we will sit and then discuss as to how we move forward. Honorable Mutapo.
Okay, thank you, Chairperson. Okay, in relation to Section 10, for now, let me withdraw that statement until I get that information. Yes, because it might be misleading. Yeah? Yes, it might be misleading. So Chairperson, on the issue of us discussing this, no? I think we should also take into consideration some processes which are to be unfold and the other issues, us going on recess and a lot of things which may derail us. So I think the sooner we engage in relation to the matter before us, the better, Chairperson. Thank you.
Honorable Skosana.
Yeah, Chair. No, Honorable Chair, thanks. We acknowledge the presence of the Honorable Minister. Yeah, well, I wanted to say I concur with you that I think having received the briefing today from the department, I think it will be important that we sit and look at it. But I think what I need to emphasize that we need to do it urgently, because I think the concern from the Deputy Minister, it was the issue of time frame. So just to try and speed up the process so that we don't delay, I think, the whole process. Let's just, if we can have put a date and have a date, having received all the other required documents and look at it, just for us, for all of us, just to have clarity. Obviously, it's not us alone who are going to take a decision. It has to, like the Minister indicated, go for public participation process and stuff. But it's just for us to clear our understanding, because I think somehow there are some fine line that differentiate what can be exempted and what can't be exempted. Just those little things. But I'm just saying, let's just do it quickly so that we don't delay the process.
I think the documents that Honorable Mutapo referred listed, and the reports from your engagements, if members of Parliament can have all those, that will help us to come up to speed. So how soon can we get the documentation from your side?
Chair, just did you want the documentation? You want a report on the public inputs? That's the one I understand. What else do you want?
I think we will write to you.
Okay, but Chair, I would urge that you do put out the bill for comment. The bill has been tabled in Parliament. Do the public not have the right to say what they think of the bill? Or are you going to take a decision that you're not going to engage in the bill? As the Minister had said, you would need to be guided by what the public think.
Deputy Minister, could we just request that you allow the committee to follow its processes as a committee of Parliament? I think what I hear is that we will sit as the committee, and then we appreciate the urgency of the matter, and then we will take this bill forward, and we want to take it forward.
Chair, I've never heard of that happening before, that you don't put out a bill for comment.
Honourable members, let me not decide for you. What are you saying?
Chairperson, I propose that we release the department and media, then we remain behind for 30 minutes.
Briefing that we're putting.
No.
What is the time?
No, the international crimes bill, eh? Okay. Maybe immediately thereafter. Yes.
Just to indicate that indeed we defer to the fact that we are the executive and you are the Committee of Parliament, and there comes a point where we have to respect separation of powers. So you decide how best you manage your work. If you need any support from ourselves, we'd be more than happy to oblige. Thank you.
Thank you,
Minister. And we can say for the record that we see the urgency of the matter in the light of the increasing intolerance. We want to take this matter forward, but we are just saying that as the committee, we just need to sit on our own and clarify certain things, and that should not take long. Thank you very much for helping us. Can we move on to the international?
Okay.
Yes, Honourable Minister, we are in your hands.
Chair, I am going to leave you in the capable hands of two very capable ladies, Calais, who you're familiar with,